Chesterton. This is Rosalind. She is a person of many interests and a lot of very interesting things she does. She's fascinated with professional baseball, but she is probably best known as, for lack of a better term, the patron saint of cartoonists. It was her brainchild that led to the Friend of the Court brief that was filed in the Hustler case, which in my opinion and the opinion of many others was central to turning the court in favor of supporting satire, even satire that wounds, even satire that is offensive to some. And I always tell my students that, and on the website for this event, her brief is accessible, so if you choose to go online today, which you certainly may do, there are instructions on the back of your panel on how to access, pamphlet on how to access email and internet. You can take a look at that brief, but I'm sure she'll be talking about it in more detail here. In any event, with no further ado, I'm going to introduce Rosalind, who, again, has not only done this work for a very long time and with great grace and wit and wisdom, but she's also done it for free, which is something to be noted in this commercial world in which we live. So take it away.
Thank you very much, Jane, and I must thank, again, the Silha Center, the Hubbard School of Journalism, the Silha family, and all of the individuals here who've made us so welcome at the University of Minnesota, and also my friends and colleagues for many decades at the Association of American Editorial Cartoonists. Our first panel today is foundational. It's about the case between Jerry Falwell and Larry Flynt. Joining me are two outstanding editorial cartoonists, precious national assets, along with all the other cartoonists who are at this symposium. First, to my immediate right is Ben Sargent. Ben had the good fortune, and it was my good fortune, to work with him 30 years ago when he was president of AAEC. He worked for 40 years as the editorial cartoonist with the Austin American-Statesman. His work is now seen on the Lone Star State section of the Texas Observer. One of his editors said about him that, "Don't be mistaken by this courtly gentleman with impeccable manners. He brandishes, quote, a weapon containing a blend of black ink, arsenic, rattlesnake venom, and laughing gas." Next to Ben is Mike Peters. Mike Peters is the Peter Pan of cartooning. I can vouch for that because at the 25th anniversary of his work at the Dayton newspaper, he flew in, literally, in a Superman costume. I'll never forget it. He draws the full spectrum of cartoon art, lacerating political cartoons, and also the weird and charming world of Mother Goose and Grimm. Both Ben and Mike are Pulitzer Prize winners. So to set the stage this morning, I'd like Ben to tell us how AEC became involved in this famous case. Oh, I added 5, so I think I need to get out of this so you can do yours. There you go.
Good. Here we go. There it is. Make it come up.
Do we have to hit
There
that
it
thing?
is. Oh, yeah, slideshow. There? No. All right, here. Voila. All right. Well, good morning, everybody, and thank you, Rosalind. I am Ben Sargent, and I'm very pleased and privileged to be able to take part in this discussion of Hustler Magazine, Inc. v. Falwell. Proud both still to be around 30 years from the decision of the Supreme Court, and to know that the case still stands as a bulwark for free expression in these very perilous times. I was editorial cartoonist for the Austin American-Statesman for 35 years, president of the Association of American Editorial Cartoonists at the time we took part in Rosalind's strong amicus brief in that case. Currently staff cartoonist for the Texas Observer and proudly a career-long enemy of the people. Hustler v. Falwell arose, as I'm sure you all know, from an ad parody in Larry Flint's notorious magazine in which the late political televangelist Jerry Falwell allegedly reminisces about a drunken, incestuous relationship with his mother in an outhouse. The affronted preacher sued the magazine for invasion of privacy, and I was going to ask Rosalind the legal question, does that mean that it actually happened and he just didn't want us to look in the outhouse? Libel, and most importantly to this case, a tort that in Virginia was called intentional infliction of emotional distress. The trial judge turned down his privacy claim, and the jury turned down his libel claim, but it ruled in favor of Falwell on the emotional distress claim. The Federal Court of Appeals affirmed that decision, and up it went to the Supreme Court. The issues, as you'll hear in the final appeal, were stark ones for the American principle of free expression. If the court held that a public figure could silence criticism just because it made him feel bad, the entire foundation of the First Amendment's speech protection would essentially be rendered meaningless. The case was argued in December of 1987, and on February 24th, 1988, the court, with the Chief Justice himself writing the opinion, decided unanimously in favor of Hustler and of the continued health of free expression. Chief Justice Rehnquist wrote, quote, "The fact that society may find speech offensive is not a sufficient reason for suppressing it. Indeed, if it is the speaker's opinion that gives offense, the consequence is a reason for according it constitutional protection." Before this case, the AAEC had not been active in First Amendment litigation, despite the essential foundation the Constitution's free expression protections provide for cartoonist work. Rosalind, who was then a young lawyer for the Washington firm of Dick Steen, Shapiro, and Morin, was keenly interested in the Hustler case and its wide-ranging implications, and she knew that the son of partner Charles Morin was our friend and colleague Jim Morin, then cartoonist for the Miami Herald. Jim brought Rosalind together with the AAEC and its then president, Etta Holm, in her pro bono preparation of our amicus brief in conjunction with the Authors League of America and comedian Mark Russell began. The amicus brief, of course, was focused directly on the existential damage that a decision in favor of Falwell would do to satirists of all sorts, especially in a medium such as cartooning. It was an eloquent argument for the place of satire in a free society, and the Chief Justice even quoted from it extensively in his opinion. Satire, he wrote, is often calculated to injure the feelings of the subject of the portrayal, but it cannot be suppressed without fatally injuring the right of Americans freely to speak and to publish. Since the 17th century, the foundation of English and American thought on free expression has been the idea that in a free, unsuppressed marketplace of ideas, the truth will triumph through its own merits. The English Bill of Rights incorporated the seed of that idea, and the First Amendment to the United States Constitution brought it to full and robust flower. In subsequent centuries, the Supreme Court has gradually but steadily enlivened and strengthened the amendment's spare language, and Hustler is one of the crown jewels of those free speech cases, and we were very proud to be part of that. Mike, going to go next? Or you? I'll go back to Rosalind now. Thank you.
Need a little help here for, now that I got you all set, let's see if I got it. I think we're set. Am I good? Are we good? No, we're not okay.
Hit it right there.
Okay. No. Friend will come up here. Holy something. All right, we need
It's
our
just
friend
bottles.
to come back up here. Just not on the screen, it's over here. That would be good.
There we go.
All right, thank you very much. Thanks, Ben. So here we are looking at the offending ad parody. It's important to note that at the bottom, the original publication said ad parody not to be taken seriously. Even in the table of contents, the ad was listed under fiction. Nonetheless, Reverend Falwell sued and won, as Ben recounted. He sued for $15 million. And the jury awarded $100,000 in compensatory damages and another $100,000 in punitive damages. The mainstream media was really perplexed about what to do about this case. Chief Justice Rehnquist, Justice Scalia, and other justices were considered to be hostile to the First Amendment based on their decisions in many, many cases over many years. And the discussions among the media bar were that maybe it would be safer to let this decision stand, and maybe it'll be a one-off, and a very rare case where the plaintiff will win, but there won't be a broad holding. I was really worried about this case because 50 different states had different authorities for suing for emotional distress. And if Reverend Falwell had prevailed, I could see a scenario where not only cartoonists, but other satirists could be hauled into court. And even if they prevailed after many months and years and being driven to the poorhouse in defending these kinds of lawsuits, it would be a real threat to free speech. So in talking with just one or two people, including Jim Moran, the son of the senior partner in my law firm, and with Ben and his colleagues at AAC, we saw an opportunity, a strategic opportunity that was a big risk. And the risk was to play our argument to these two justices, the most conservative on the court, the ones who were most hostile to the First Amendment in their decisions. Chief Justice Rehnquist on the left and Justice Scalia on the right. I had heard just through normal conversation among lawyers who practice before the court that both Chief Justice Rehnquist and Scalia liked a good laugh. They were both very serious students of American history. And so the idea emerged that our brief should focus on the long tradition and rich tradition and important tradition of political satire, not only in American history, but in Western civilization. Our brief consisted of two parts. The prose or narrative part that documented the case law that we thought supported our position, that Reverend Falwell's claim and the verdict could not stand in the face of a First Amendment challenge. And then an appendix, it was equally long as the prose part of the brief, of political cartoons, going back to Thomas Nast. I'm showing just a few of them, but as Jane said, the online version of the brief, you can see the full appendix of political cartoons. And we decided to not just show cartoons depicting American national political figures, but figures who were important in state and local communities. There's Walt Kelly's Pogo, some other cartoons of the era. Signe Wilkinson, who you'll hear from later today, we had one of her cartoons depicting a controversy involving a judge, I believe, in her community. This is a cartoon I did not include. You may recall that when Justice Rehnquist was Associate Justice, he was nominated to serve as Chief Justice of the court and had to go through a second confirmation hearing before the United States Senate. At that time, it was revealed that he owned a home that had a deed with a restrictive covenant. These were covenants from 100 years before. They were boilerplate, and they restricted people of color, Jews, and others. When that came to light, it created quite a kerfuffle in the course of his confirmation hearing. So here we have the late, great Paul Conrad, the lacerating cartoonist with the Los Angeles Times, drawing Associate Justice's valet, approaching him and asking, "Justice Rehnquist, will you be wearing your hooded white or your black robe today?" So Conrad sent me that cartoon. I had invited the cartoonist to send me their stuff with the caveat that I wanted cartoons for the appendix that would make the subject cry. I thought, no, that's a shorthand way of depicting emotional distress. Conrad sent me one cartoon. This was the one. And I was nervous and just decided not to include it. But I must share with you that in 1991, years after the Hustler decision, I had the good fortune to sit next to the Chief Justice at an event in Williamsburg celebrating the 200th anniversary of the Bill of Rights. And he was chit-chatting with his arms crossed and said, "Oh, have you ever been before our court?" And I said, "Only on one occasion." "What was that?" "It was the Hustler case." And he said, "What was your role?" I said, I wrote the cartoonist brief." He said, "Oh, that was a really powerful brief." And I said, "Well, I want to tell you about a cartoon that we didn't include." So I told him about the cartoon, and he remembered it, and he said, "Oh, you should have included it," in hindsight, perhaps. Just to give you a flavor of how hostile the Chief Justice had been in free speech cases, I'll share this one statistic, courtesy of Professors Jeffrey Stone and Harry Calvin Jr., who determined that in 259 speech or free press cases in which Rehnquist participated, he rejected the First Amendment claim 80% of the time. So that was the scenario we were dealing with when we were writing the Hustler brief. The oral argument was thrilling. Pat Oliphant, the wonderful editorial cartoonist who unfortunately couldn't be with us today, was involved in working on the brief with me, and the day before the oral argument, he asked if he could come, and we got him a press pass, and so he joined me, and I'll show you some of his sketches in a moment. But here's a bit of the flavor of the oral argument and how our brief figured prominently in the discussion. This is the voice of Chief Justice Rehnquist.
What about a cartoonist who sits down at his easel or whatever cartoonists sit down at and thinks to himself, candidate X for the presidency is just a big windbag, a pompous turkey, and I'm going to draw this cartoon showing him as such. Part of his intent, he enjoys cartooning and just likes to make people look less than they are, to show up the dark side of people. But he knows perfectly well that's going to create emotional distress in this particular person. Now, does that meet your test?
No, because it does not, unless what he depicts is something like showing the man committing incest with his mother when that's not true, or molesting children, or running a bordello, or selling narcotics.
But what about the state of mind required from the defendant?
Well, the state of mind is precisely what we are concerned with.
But what about the state of mind I've hypothesized to you? Does that satisfy your test for the Constitution or not?
No, it would not. If the man sets out with the purpose of simply making a legitimate aesthetic, political, or some other kind of comment about the person about whom he is writing or drawing, and that is not an outrageous comment, there is no liability.
Even though he...
Okay. Let's see. If I could get back to my... here. All right, I need help one more time. Sorry. All right, and so engaging with the lawyers also was Justice Scalia. And I'm going to play a little bit from him, but I need help again to get back to my, told you I needed you here. So I want to go to this one.
Yeah,
And I went down there and it didn't move.
there we go.
Okay, perfect. Thank you. So Mr. Grutman was representing Jerry Falwell, and here's the exchange with Justice Scalia. It's not working. One more time. Sorry, all my lessons are not working. The audio's not here. Why don't you just stay here if you can? Sure. Okay, there we go.
Mr. Grutman, you've given us a lot of words to describe this. Outrageous, heinous,
Repulsive and loathsome.
repulsive, and loathsome. Well, I don't know, maybe you haven't looked at the same political cartoons that I have, but some of them, and a long tradition of this, not just in this country, back into English history. I mean, politicians depicted as horrible-looking beasts. And you talk about portraying someone as committing some immoral act. I would be very surprised if there were not a number of cartoons depicting one or another political figure as at least the piano player in a bordello.
We don't shoot the piano player. I understand that.
Well, but can you give us something that the cartoonist or the political figure can adhere to, other than such general words as heinous and whatnot?
Yes.
I mean,
I think
does it
we
depend
have
on how
become-
ugly the beast is, or what?
It's not the amount of hair the beast has or how long his claws may be. I believe that this is a matter of an evolving social sensibility.
All right, thank you. Fortunately for us, Pat Oliphant brought his drawing pad, and he depicted Falwell's mother here. And here he's depicting Jerry Falwell beaming with terribly hurt feelings. And here is Reverend Falwell's lawyer, Norman Roy Grutman, as a whorehouse piano player. All right. So as been recounted, the court unanimously reversed the judgment in favor of Reverend Falwell. After talking about and borrowing from our brief about the long tradition of political satire, he said, from the viewpoint of history, it is clear that our political discourse would have been considerably poorer without political cartoons. And ultimately, he said, outrageousness in the area of political and social discourse has an inherent subjectiveness about it, which would allow a jury to impose liability on the basis of the jurors' tastes or views, or perhaps on the basis of their dislike of a particular expression. An outrageousness standard thus runs afoul of our longstanding refusal to allow damages to be awarded because the speech in question may have an adverse emotional impact on the audience. This, as we'll hear in the course of the rest of the day, this decision has been cited in many cases since 1988. And there's been a tremendous amount of scholarship on just how it was that the Chief Justice came to author one of the most ringing endorsements of the First Amendment, given his background. Thanks to research by Roger Newman, this high school yearbook of the Chief Justice was discovered not many years ago, and the entry for Mr. Rehnquist was, "The favorite pastime of Bill in and out of school is cartooning." You know, So I've since learned that he was quite the doodler, hoping somebody's going to look at the archive at Stanford, I think the Hoover Institution that has his materials, and we'll have many more years to excavate the origin of his passion for political cartoons. But we were very fortunate that that was the case, and fortunate to have gone on this wonderful journey in endorsing the First Amendment. The last slide I want to show you is the cartoon that Pat Oliphant published right after the decision came down. Dear Mr. Flint, in order to defend their constitutional freedom of expression, satirists are forced from time to time into reluctant association with people like you. In celebration of the excellent Supreme Court decision, Hustler v. Falwell, I trust you will accept the accompanying depiction of yourself as strictly satirical. So now I'm going to turn it over to Mike Peters to talk about the environment of the moral majority and what it was like in the 80s and for cartoonists to be drawing at that time.
Well, first of all, I think all cartoonists ought to have a little picture of Roz next in their bedroom where you light incense and stuff, because truly, satire. I mean, satire is something that we live with, and we sort of take for granted that, oh yeah, we can do this. When Roz was saying that Rehnquist and these people were saying, well, what do these people want to do? They wake up in the morning, want to make fun of elected officials? Yeah, that's exactly what we do, or most of us. Mike Ramirez is not here, but we that's what we do. I thought that that Nixon was my as a great writer once said, he is our Camelot. This is the greatest time for American satirists until, of course, Trump came along, and then we have just surpassed that, and we're having such a great time. It's horrible for the country, but but at the time, you guys, when the Falwell thing was going on, when the Hustler case was being brought to the Supreme Court, when Roz and some of the other people were defending our right to be able to to do what we believe and make fun of these people, or at least go out after them, that satire was truly under attack. And at the time, I had done a cartoon about. I grew up a Catholic. I'm not a very good Catholic right now, but at the time when I was growing up, being Catholic was a big deal, and I was going to church and all this kind of stuff and doing what you're supposed to do as a Catholic, and I truly believed in the whole idea of Jesus and what Jesus was saying. And I thought one of the things that I believed was that my job is supposed to be trying to, be a backer of this. And so, okay, now I need your friend. Where's Will? Where's Will? Will, you were supposed to be sitting down there. Okay, hit this. Yeah, hit where the cartoon is. It's right there. No. Hit that. Or wherever that is, you hit that. Oh, good. And I had done this.
Tiny icon.
Okay, fine. Thank you. If this man were a candidate, he'd be healing the sick, caring for the poor, feeding the hungry, for equal rights for all, and against capital punishment. Therefore, he'd be unacceptable to the Christian right, or at the time I had moral majority. This was by far the greatest cartoon for me to get a response over. I had people writing in. I had some demonstrators. I had, one of the things I remember was I had a teacher who wrote to me, and she had all of her kids, at the time the kids read the newspaper and stuff. I actually opened up the paper and looked at the cartoons. And she had the kids write to me and to explain what this cartoon meant. I mean, how amazing is that? And the kids wrote their little letters to me explaining what this cartoon meant. And they saw the irony. They saw the irony in this thing. And at the time of this cartoon, I couldn't find the cartoon, the actual cartoon, which had unacceptable to the moral majority. And but I couldn't find this cartoon, so I redrew the cartoon. And my wife said, well, "Wait a minute, this still holds up. Put this cartoon in the paper." And so I did. And once again, I'm getting most response from this cartoon that I had done 38 years ago, but it was this cartoon. And the children told me what this cartoon meant, which was such a great thing, because they understood what I was trying to say using irony. When this cartoon came out, some people wrote that, you got to remember, you don't have anything in there about abortion. And when I was saying for equal rights for all, that's what I meant. I meant for equal rights for all. I meant if I went to an all-boys military Catholic high school, a Christian school for the criminally insane, so when these people are saying that I'm not talking about abortion, I am talking about abortion, equal rights for all, equal rights for all. And I've done some cartoons, and I don't know where they are, and I'll show you at some later time what if men became pregnant. If men became pregnant, if a man became pregnant, equal rights for all, then abortion would be a sacrament, would be chosen by our Supreme Court or by our Congress to say, oh yes, abortion is something that we need, equal rights for all, that women should be treated like men and men should be treated like women. My mom had a TV show in St. Louis where I grew up, and it was a show that she went on she started in 1949 and went until 1972, 73. And she sang and danced and then had politicians argue to each other and stuff. And it was exactly this. It was exactly this, that we see something that we think is wrong and we draw cartoons against it. And that's what Roz and her compatriots was fighting for that day, that week, that month. That she was giving us our right to be able to say what we believe. And I didn't know that we were allowed to go to the Supreme Court, or else I would have begged her to let me come at the same time. But like a fool, I did not know, and I didn't know Roz well enough to be able to ask her. But truly, she is an amazing lady, and she and her husband has saved my butt, pulled my butt out of the fire many times. But as a cartoonist, as what we do wake up. I remember talking to Paul Conrad, who is probably one of the greatest cartoonists of our century, and he would wake up every morning, and she and his children would hear Paul Conrad walk downstairs and open up the door and then start cussing when he read the headline, whatever it was big. God damn it, I'm gonna, like this. And he would do that every day during Nixon because that was our job. That was what we were supposed to do, is to go out after these people. And so So I've said just about all I need to say. What's that? Okay, I can show you some of my cartoons. Will can show you some of my cartoons. Now, Will, come on up here. This first cartoon is a cartoon that, okay, thank you. Stay right here. Cartoon that says, quiz. Pick the superhuman being who works a 40-hour a week at the Daily Planet, then comes home and cleans the house, does the dishes, washes clothes, makes dinner, chauffeurs the kids, balances the budget, buys the groceries, irons, mops, and sews. And so is it Superman or is it Lois? I had at the same time during this period, the IRS was being voted on, and it was voted on by all the states. It was being a constitutional amendment, having all the states voting that women should have, ERA, that should have an equal rights amendment, and not IRA, and so I did up this cartoon, which Superman is one of my heroes, but I realized that Lois was one of my heroes too. Okay, here's another cartoon. You are so wonderful. This was a little bit later, but I had done this cartoon. A girl says, I was born in a ghetto, unwanted, uncared for, abused, molested, raped. Now I'm 14 and I'm pregnant. Tell me, when does life begin? When does life begin? I was a Catholic, and I went to church all the time during this period. And my newspaper was next to I want you to stand right here. Don't leave. Okay. Was next to a church called Sacred Heart Church, and it was right behind my newspaper. And I would go there at lunchtime and hear Mass. And so I was going almost every day, and there was a priest there called Father Greasy, and Father Greasy, I never met him. I met him one time in the confessional, and I told him that I was I confessed, that I was doing bad things with my body, and he said, "You what? You what? You're too old for that." He didn't even know me but he didn't know I was the cartoonist. And he said, "How dare you?" And I walked out, and people are looking at me, and he's screaming in the thing. I mean, I didn't kill anybody. I was just doing bad things with my body. And but one time I was sitting there, and Father Greasy had this was doing a sermon. It was a Sunday, and he stopped the sermon. And he says, you in the shorts, stand up. And this girl with the baby stood up, and she was wearing shorts. He says, "I don't allow shorts in my church. Get out, get out." And this girl, of course, left the church for the last time of her life. She carried her baby, and she had little shorts, and she left. And I was there, and everybody was stunned, that he did this. And so the next day, I did a cartoon of Father Greasy standing there next to the cross, and said, "You with the shorts," and he's wearing, and he's, Jesus, and get out. I don't allow anyone with shorts in my church. Well, about 2 or 3 years later, Father Greasy had picked me as a horrible person, and so he was in Fatima, Our Lady of Fatima. He was in France or wherever that is, and he sent me a card, and he said, and on the back it said, "I'm in Fatima and I'm praying for you," and on the front, he signed it, he addressed it to Judas Iscariot, Dayton Daily News. Now, and now what was weird, now I'm in my office, and the card came through the Dayton Daily News, the journalism, our letter writers. And somebody down in the letter writer said, "Oh, Judas Iscariot, yeah, that goes up to Mike Peters." It didn't have my name. It just said, "Oh, yeah, Mike Peters. That's right up there, Okay, all right, okay. And then this last cartoon is just basically what I was telling you before. Nothing can, is a choice. Nothing will change my views on abortion. And then all of a sudden he looks down, and then he sees that he's got a baby in his stomach. What I was trying to say, of course, is that, if men were pregnant, truly it would be a sacrament. And so, abortion. And so, so thank you very much.
One of the things we're trying to do in this symposium is to fast forward what the current media environment is like and how the Hustler decision has endured or factors into that. So I want to go back to Ben and ask him whether the very different media environments of the 1980s and today affect how the hard-won protections for free expression are applied.
All right. Thank you, Michael. An interesting aspect to me of marking the 30th anniversary of Hustler is that while its conclusions and principles are unchanged, the media environment to which they apply is fundamentally and substantially different from the seemingly long-ago world of 1988. In the intervening 30 years, information media have undergone a complete transformation, particularly in the field of opinion cartooning. In 1988, the model for editorial cartooning was the full-time staff cartoonist expressing his opinions on the editorial page of a daily newspaper. At that time, there were probably 250 such cartoonists working in the United States, and now there are probably, I don't know what the accepted number is right now, but probably fewer than 50. And cartoonists who are working tend to work in a much more unstructured environment. Over those 3 decades, of course, the ways we receive, process, and share information have undergone a fundamental change from the old forms of printed paper and traditional broadcast to the new and still evolving forms of digital media. The work of the devil, in my opinion, but both forms work in ways that are both intrinsic to their character and substantially different from one another. Traditional print and broadcast media were socializing forces. Daily, they gathered everyone in a community around the same campfire to hear the same stories at the same time. And for opinion journalists, this lent substance and authority to their words and pictures, knowing that they were heard by the whole community at once and backed up with the implied authority of the newspaper. Digital media, on the other hand, are an atomizing force. They tend to take information, split it into a billion grains of sand, and constantly combine and recombine the grains in ever-evolving and unpredictable ways. In this environment, an opinion journalist has no particular platform that has its own implied substance and authority, so his expressed opinion, one of millions flying around in the ether, must rely on whatever internal authority it can command. Even if his cartoons are in a newspaper, that platform has been diminished by a loss of circulation that makes most newspapers no longer a commonly experienced medium in the community. The messages of opinion journalists in the new media environment, while they may be afforded unknowably wide circulation, are necessarily made ephemeral and diffuse. But while this revolution has remade the media world, our legal and constitutional free speech protections have fortunately remained unchanged and intact. With particular reference to cartooning, how will they still apply and how will they continue to provide their essential protections to liberty? On the one hand, the new media environment may discourage action by offended targets because the cartoonists and their works are widely scattered and the audience reached, and thus their effect is practically unknowable. On the other hand, cartoonists generally lack in the new environment the institutional and financial heft that newspapers once had, which may leave them more vulnerable to litigation from offended parties. Although I might point out that other than the New York Times and Times v. Sullivan, the defendants in some of our most significant free expression cases were not particularly influential people. John Peter Zenger was a German immigrant printer. Clarence Brandenburg was a rural Klan wizard. Charles Schenck was a local Socialist Party hack in Philadelphia. And J.M. Neer was a racist and anti-Semite right here in Minneapolis, and so on. However things play out in the new environment, however, for now we can trust that the hard-won protections from the First Amendment's long history are still in place, and we should be vigilant to ensure that they are defended, strengthened, and expanded. Speech is still speech, and liberty is still liberty. Thank you.
So before we take some questions, I want to pose a question to Mike, and it's a question that I think will be the thread that we pull throughout the day today, which is, why has satire been so powerful? What is the unique power of editorial cartoons? I just want to toss that to Mike.
Of course. Is this on? Can you hear me?
Is that on?
I'll talk loud.
There you go.
Well, first of all, there's a great line by Boss Tweed about Thomas Nass, and he said, the Boss Tweed said, my people who know me and respect me can't read, but they can see those damn cartoons, and it is true. It is true. During Vietnam, we had great editorial writers who James Reston and people like that, who wrote things that eventually them and then the demonstrations helped turn the country against Vietnam. And I think also the TV networks showing what the war was like helped turn helped turn the country against, and Walter Cronkite, and all these people helped turn the country against Vietnam, and that we should get out. So there are many great editorials who came out every single day. A cartoon comes out, and you look at it for we thought 3 seconds, 4 seconds, maybe to read it. 1 1000, 2 1000, 3 3 or 4 seconds. And a cartoon can't change your opinion. Say, I hated Nixon, or I love Trump, and now I hate Trump after seeing this cartoon. That doesn't work like that. But what a cartoon can do is leave a lasting image in your mind about a certain subject. David Levine did a great cartoon, who, by the way, never won a Pulitzer Prize, and that's frigging outrageous. Great illustrator for New York Times and a book review and stuff. But there was a great cartoon that he did that summed up for sure a certain period of time in Vietnam, and it had LBJ lifting his shirt. Where there was a photograph of LBJ lifting his shirt and showing a scar that that he just had on his stomach for something, maybe taking out an appendix or something. But David Levine drew him raising his shirt, and there was a scar of Vietnam there. How cool is that? And it's something that I'll never forget. I will never forget. And there are certain cartoons, and of course none of them come to mind, but they may come to your mind. Certain cartoons about certain issues that leaves a branded image in your mind about that certain subject, and that's why satire is so strong. That's why cartoons are so important, and so.
So we have some time for questions, please.
No, not all at once. I know there's so
Yes,
many.
sir.
Yes, go on.
Rosalind, this may not be true, but I heard last night at the party that you actually should have recused yourself from that case because you had dated Jerry Falwell. Is that true?
I should really win an Academy Award for trying to herd 12 Pulitzer Prize-winning cartoonists and the likes of you to ask a question like that.
That's not
Uh-oh. Any other questions?
Yes.
Yes.
Mike Peters did create a cartoon that has lasted a very long time for me. It was about the environment. It had a guy sitting behind a desk saying, "You want coal? We own the well.
Oh, yeah.
You want oil? We own the well. You want nuclear? We own the uranium. You want solar power? These are
You know,
go.
it turns out that was one of
There you
my,
go.
that was one of my cartoons that people bring up all the time. I mean, not, yeah, not just you, but people. I mean, just people.
Many people.
And, yes.
Many
and,
people.
But it came from the heart. I mean, it came from the heart, big oil. And, you know, and so, and I may want to come up with that again, just like I did with this cartoon, because it still is
relevant.
relevant, you know.
Yep.
But thank you. It's I mean, it's interesting when cartoons, like many of the things that Ben does, many cartoons that you actually feel, you feel and you want to express it, and it comes from the heart, stays with people, and it doesn't, I mean, it lasts forever because you were so lucky to have thought of it and been able to draw it and then have a forum to be able to show it to the whole city or to the whole country if you're syndicated, you know. And so that was one of those cartoons.
Yes.
I just have two quick questions. First, were you surprised when Scalia and Rehnquist were the two main arguers or questioners during the case, and that they paraphrased from your brief?
I was so relieved when I heard the questions that they were asking. I just relaxed. I just felt we'd reeled them in, at least long enough to pause and think what the consequence of a decision upholding the verdict would be. I was surprised. I was very surprised. I mean, you were at the oral argument, Jane, and I think we were all just holding on with white knuckles, waiting to see what the tenor of the courtroom would be. And I think you got a little flavor of it from the audio clip. And once laughter erupted and you could see those two justices were really engaged and the most engaged, we thought we had a chance. As far as lifting portions of the brief, the highest compliment.
Okay, my other question, do you think that Larry Flint was at a distinct disadvantage because he had called that same court 8 assholes as opposed to cunt?
Exactly. Exactly.
Repeat the question.
Larry Flint had been a protagonist in the court previously and had made some raw comments about the justices. I won't repeat. But as a consequence of that, he was cordoned off on the day of oral argument in a kind of, not a cage, but he was sort of off on his own in his gold-plated wheelchair. I mean, how weird was that? So I think he paid a price for that outcry, but he was allowed into the courtroom. Yes.
One of the clips you played
Okay.
had to do with Rutland, Falwell's attorney, really proposing a test that was a lot like actual malice. That this is a false statement about an incestuous relationship. And the jury had really done your side a favor by saying that nobody would have accepted this as a real false statement. So they lost on the libel claim at trial. Do a little alternative history speculation that if they had not had an intentional infliction of emotional distress claim, and the jury had to focus on libel, where emotional distress can be an element of damages, might the jury have said, this was a false statement, it was defamatory, and then how would the court have dealt with the satire issue? Could it have taken the more difficult route of saying no reasonable juror could have found this was a factual statement, and therefore all the rest flows? Or would it have punted and said, you know, this is just a straight garden variety libel case?
Right. Well, we'll never know, but we have some wonderful First Amendment lawyers who will be entertaining you for the balance of the day. And I'll be interested to see what they might have to say about that. But fortunately, the jury had found that no reasonable person could believe that this Campari liquor ad parody was stated as a statement of fact, that Reverend Falwell had had sex with his mother in an outhouse. So you're right, the jury had done us a huge favor, and who knows what course it would have taken had the jury found otherwise on the libel claim and used the emotional distress damages as the damage part of that tort. We'll never know.
Now, is it true that in Canada they don't have a law like that? Is that true, or am I wrong?
I don't know.
Okay.
Don't know.
All right.
Yes.
You asked, what is it that gives satire so much power? And Mr. Peters responded, explaining why a visual image might give more power than the written word. But of course, we've had satirists from the written word, Twain, Swift, Lincoln. What is it about satire that gives it so much power?
Well, we have a whole parade of people who are going to answer that question on the balance of the day. And if you look at our friend of the court brief, we quote from Pope and other narrative satirists. So it's not just the visual satire that is so powerful. You know, throughout our history, Mark Twain, many other satirists have been equally effective spokespeople and commentators. You're right. Anybody else want to speak to that? Okay. That's good. Oh, all right.
Okay.
So we're done. Thank you all very much.
Thank you, guys. Your thing is amazing. You're amazing.
I'd love to have it go on and on and on, but we can't because we have to prepare for our next panel, and we're not having a break between this first panel and second panel. So I'm asking the panelists to please get down here with all deliberate speed, and please, if you're going to leave, don't go away for too long because we do want to get started again right away. I'll also add that in addition to all the discussion about law and satire and all that good stuff, we're also going to be having a discussion starting around 2:20 on threats to satire both here and abroad. So very possibly Mike Peters' questions about the laws in Canada, which are quite different from the laws here in the United States on this issue, will be answered. While the panelists are coming up and taking their places, and please panelists do come up and take your places. I'll go ahead and introduce George Freeman, who is the moderator of this panel, very quickly. He's currently the executive director of the Media Law Resource Center. Prior to that, he was of counsel to the law firm of Jenner and Block, but for many of us, he will be forever associated with his role as assistant general counsel of the New York Times Company, where many of us worked with George when he was in the forefront of many high-profile cases. He speaks very frequently on these and other topics, as you can imagine, and also teaches at Columbia, New York University, and CUNY's Graduate School of Journalism. So, George, take it away.
Thank you, Jane. Thank you very much. The good news is, unlike the prior panel, we are really low-tech guys. We have no audio visuals, so we're not going to dally around here with this machine. We're just going to talk. Two other things I would note. One is that the two justices got beaten up in the last panel. And while I think Chief Justice Rehnquist very much deserves to have done so, there is one good thing about him. I went to Amherst College, and you'd be surprised to know that Justice Rehnquist's son has been the leading scorer in Amherst College history in basketball in its history. So there's something positive there. As to Justice Scalia, I'm no great fan of Justice Scalia, but the fact is that Justice Scalia was actually a pretty strong First Amendment judge. He usually was on the right side of First Amendment cases, including the most critical one, which is the flag burning case. He was on the side on a 5-4 decision that said flag burning was okay and couldn't be punished. So he really wasn't a bad First Amendment justice. Anyhow, with that as an introduction, let me introduce the panel. To my immediate right is Len Niehoff. Len is a professor of law at the University of Michigan and also practices law at the Honigman firm in Michigan, in Detroit. Next to him, to his right, is Erica Salkin, who's a professor of communications at the Communications School at Whitworth University out in Washington State. To her right is Jonathan Peters. John is a professor of communications at University of Georgia, and I have got to know him a little bit because he also is the press freedom correspondent at the Columbia Journalism Review in New York. And out on the far right, which is not probably where he belongs, is Steve Breen, who's an editorial cartoonist for the San Diego Union. So let's get started because we don't have much time. And I just want to start with the opinion itself, talk a little bit about satire, and then really, in the main, talk about 30 years later, what's the legacy of this case, how important was it, what's its influence and effect today. But going back to the opinion, just briefly, Justice Rehnquist started his opinion by saying that A, the material was clearly false, B, we really don't protect falsity, we protect truth, and C, it was intentional infliction of distress, and the defendant, in his deposition, Flint said his aim was to hurt Falwell, so it was intentionally intended to inflict pain. So given that that's the way the justice started, how did they ever come around to turn that around to a decision in favor of the publication? Because it was kind of a bad start, and his premises are all pretty negative. Glenn?
Corrective note, Justice Rehnquist also gets something a little bit wrong at the beginning, and it's useful because it helps highlight just how outrageous the satire was. Justice Rehnquist says that the parody suggested that Falwell's first sexual experience had been an incestuous drunken rendezvous with his mother in an outhouse. That's a cleaned up version. If you look at the parody closely, actually it says that he had to get a goat out of the outhouse in order to get his mother in. So the first sexual experience was actually with a goat. This gives you some idea of how incredibly charged this was. And I think that Rehnquist has an impulse and a problem. And the impulse is that this is protected. He understands the historical importance of satire. But he has a real analytic challenge, and you've hit on it, George. The problem is that when we think about protected speech, we don't think about protection coming from the fact that speech is outrageous or the fact that it is intentionally false. There's a sense in which all satire is, by design, knowingly and intentionally false, or that it's intended to stick a pencil in somebody's eye. And those are not generally the criteria we think of for protecting speech. So in my mind, while the result is spectacular, and I join everybody here in celebrating the outcome of the case, the analysis is really kind of tortured. He has to say that outrageousness can't be a standard, which I think is certainly right. But then he goes on and he sort of imports an element of falsity into the elements of an IIED claim, even though it's not there, and then he elevates it according to New York Times versus Sullivan. It's quite a lot of jurisprudential gymnastics in order to get to the result that he wants. And I think that actually says something about him, that he was willing to work so hard, even though he was struggling intuitively with why this was the right outcome. What he doesn't do anywhere along the line is explain why satire is really important. We understand that he's cheerleading for it, but if you go and look at the opinion looking for an explanation for why satire is important, I think that's missing in action.
Erica, do you want to add to that, or also maybe deal with the question of the ultimate court's decision? Did it go too far? Did it not go far enough? How would you kind of evaluate it?
Well, I think it struck the right line, at least for a broad application to a wide variety of speech. My particular area is in student speech. And when we look at how student speech cases have sort of embraced the protection of satire, we see them echoing some of the language of Hustler, especially the idea of plausibility, including for a unique audience of young people. So the idea that outrageousness is subjective and that we can evaluate sort of the intent of the speech and how it's going to be received ended up actually being a highly speech protective precedent in an area where speech regulation is kind of the norm.
John?
Sure, yeah. Maybe I can speak to the wider utility of the case, despite its analytic deficiencies. And I'll try to do that through the vehicle of recent litigation involving, it was John Oliver and HBO. So coal magnate Robert Murray recently sued HBO and John Oliver, and my work, I guess fortunately or unfortunately, depending on your perspective, was mixed up in that litigation. So Oliver's show, for those of you unfamiliar with it, it is a weekly program in which he offers a satirical view of all manner of current news issues. Back in June of 2017, Oliver aired an episode in which one segment focused on coal and the coal mining industry, and more specifically looked at it was President Donald Trump, well, then candidate Donald Trump, focusing on the candidate Donald Trump's efforts during the 2016 election to curry favor with coal miners around the country.
Let me just interrupt you for a second.
Sure.
Is Oliver kind of today's version of an editorial cartoonist of 30 years ago? Is he basically the same person?
Could be, or could be more like Mencken. Yeah, I think that would be fair. And certainly not just Oliver, but the likes of Stephen Colbert, Jon Stewart, others who engage in satire and parody. And so in this case, the segment begins by looking broadly at Donald Trump's efforts to curry favor with coal miners, then pivots and introduces you about 5 minutes into the segment to Robert Murray. Robert Murray is the founder, president, and CEO of Murray Energy Corporation, whose operations dot the Ohio River Valley. It is the largest privately held coal company in the United States. And Oliver's commentary was, it was sharp and humorous. And Murray was introduced as somebody who had been a fierce critic of President Obama's coal policies. And so, for example, Oliver said that Murray, quote, looked like a geriatric Dr. Evil. And one of the show's staff members dressed up in a giant squirrel costume to deliver the message, "Eat shit, Bob." And so the segment made clear that its commentary relied on official government reports, on Murray's own public statements. It included a number of video clips and screenshots of news stories on which the segment itself was relying. And then a few days later, Murray sued HBO and Oliver for intentional infliction of emotional distress, for defamation, and for false light invasion of privacy. One of the stories that Oliver cited on the show and offered as a screenshot was a story that I had written for the Columbia Journalism Review, in which I had documented Murray's record of suing journalists, cartoonists, and editors, and his record of threatening to sue editors, journalists, and cartoonists. So, in speaking to the kind of wider utility despite the analytic deficiencies, I'll give you just a few examples here of how Hustler came to be used in some of the litigation around Murray, because I have also written an amicus brief for the ACLU.
Let me ask you this, though.
Sure.
Putting aside all the cases, would those cases have not been won by the publisher if it weren't for Hustler?
I don't know if only because of the strength of New York Times and the fact, New York Times Sullivan, and the fact that Hustler itself relies heavily on New York Times Sullivan. And I think you could fairly argue that Hustler is part of the Sullivan progeny. Now, Hustler, of course, addresses questions that Sullivan did not. Otherwise, the court would not have accepted Sullivan for a decision. So, would we see a different result in cases like these if we didn't have Sullivan? In the Murray litigation specifically, IED claims were brought in most of those cases, and Hustler, of course, addresses that head on, whereas Sullivan does not. So I think you could make the argument that, in an alternative universe, these could go the other way.
What do you think, Len, about the case? Were you there? Were you around when this case was argued? Because my recollection was that we, and I think Rosalind kind of alluded to this last panel, I mean, we were very scared of this case. I mean, looking back on it, it was unanimous. It seems like an easy case. But at the time, the facts were so bad that we were all scared of it. In fact, I remember the New York Times didn't participate in trying to get cert, to try to, when the case went up for cert in the Supreme Court. But then once cert was granted and they were going to take the case, we grudgingly got involved. And it so happens that I found the memo I wrote to Punch Sulzberger and Max Frankel, the publisher and editor of the Times, asking them for permission to join the amicus brief. And it starts out, the first line of my memo, which is supposed to support the publisher, says, although this brief would put us in the position of supporting Hustler and Larry Flint. So it wasn't like there was a great outpouring of sympathy for the side that we were on, but it was more a matter of duty of trying to make sure that the law doesn't get worse.
Yeah, I think there were, I remember saying to somebody when the case went up, there are only two problems with this case, the facts and the law. You know, the facts were just dreadful. It was this incredibly controversial defendant. The speech was monumentally offensive. His deposition was a disaster. He admitted that he tried to inflict intentional emotional distress on Falwell. At one point, he was asked whether he was making a mockery of the proceedings. He said yes. He called the lawyer on the other side an asshole. The deposition was probably the worst deposition in the history of American law. The law was tricky because if you think about Sullivan, you know, what Sullivan did is it took a tort that already had these established elements and it just elevated the burden of proof as to existing elements. But IIED is different. It doesn't have a falsity element. It's not even necessarily based on speech. So I think the concern was that if, and it was a very, very serious concern, if every public figure and public official plaintiff in the country could get around New York Times versus Sullivan through the simple expedient of changing what they called the claim, then New York Times versus Sullivan was dead. And we could have a nice memorial service for it, but it was over. And so it was, I think, a very scary case, and scary also for the reasons that if you'd have told us that Rehnquist was going to write the majority opinion, we wouldn't have just been scared. We'd have been moving to other countries. That was a daunting proposition as well.
Steve, you actually do cartoons. So rather than having academics speculate on what the importance of this case was or what the importance of satire is, what are you thinking about when you actually produce your editorial cartoons? Why is satire so valuable?
Well, I think it's because you're taking something. I mean, satire is looking at something that's, whether it's a person or it's an idea, and you're basically saying you're not as important as you think you are. You know, and then there's different ways where you could knock that person or that thing kind of off the pedestal. You know, different levels of outrageousness that you could apply to do that. And first of all, I'm up here because I did take the LSAT. When I was trying to figure out what I was going to do after college, I scored in the bottom 5th percentile, but still, I did take the LSAT. So, but no, I guess you know what I would say about this is what's great about it is we don't have to worry about it. You know, we take it for granted this landmark ruling, but. You know, if you consider our compatriots in other countries doing editorial cartoons, you know, you just have to realize how lucky you are that we have something like this. You know.
Anyone else of the non-cartoonists want to comment on why? I mean, after all, there are tons of Supreme Court opinions that say we don't protect falsity, we protect truth. American jurisprudence is we stretch to protect the truth, as in the Sullivan case. But here we really are going out of our way, I think, Len, you would say, to protect falsity. And we do it really in aid of the value of satire or parody.
Yeah, I mean,
why are we doing that? I mean, why does the judicial system recognizing or making exceptions about satire and parody that allow it to do that?
Yeah, I'm extremely uneasy to talk about my views of the value of satire in front of a room full of people who actually do it for a living and who know the answer to this better than I do. But my own sense of it is that a lot of the power here for First Amendment purposes comes from the fact that satire is counterfactual. that it invites you into this imaginative process where the world just looks different. It's Donald Trump, but with a pigtail for his, at the back of his hair. Or it's Donald Trump, but with a toilet for his mouth, or something like that. And what it invites you to do is compare this alternative reality to our lived reality and ask us to consider how fair the comparison is, whether it's a legitimate comparison. And it does it efficiently, it does it quickly, it does it through a variety of devices like words and images and humor. It cuts across socioeconomic lines. And I think it's, what I think is the lost opportunity in the Hustler case is there would have been this chance for the court to talk about all the things that make satire not just defensible, but sort of a glorious part of our history of freedom of expression, and I think that opportunity was missed.
And if I could add to that briefly, speaking to the larger question of why we protect some false speech, I think that ours is a country in which we have accepted the idea that public officials and public figures ought to bear a heavier burden than, say, a private person in terms of the scrutiny that he or she can be exposed to. That is a point made clearly in the New York Times Sullivan decision, and the court in that case, and in an opinion authored by Justice Brennan, discusses at some length the concept of breathing space. And it is the idea that we protect some false speech that has not met the fault burden that New York Times Sullivan created, because we are afraid that if we held public officials and public figures to a lower standard, then it would be easier for them to sue and to win, and that would have a chilling effect on the public discourse. And so that is a point, I think, made most recently in the Snyder v. Phelps case, which doubled down on the idea that, that we are a country in which we have chosen to protect speech at the expense of some emotional harm and even some falsity.
I should just point out that Sullivan, has been referred to a lot, but for those of you who aren't totally familiar with it, I mean, Sullivan, changed libel law entirely. It basically constitutionalized it. It said the First Amendment applies to libel, which had never been the case before that. Whether it should or not, is, I think, a question academics can struggle with, but it has for 55 years or 60 years and has never been really an opportunity or even a hope to change that. So luckily now libel is constitutionalized. The rules change from basically libel being a good claim if it was defamatory and there was damage, to requiring fault on the part of the publisher and a very high standard of fault if the subject was a public figure. So it really, and it's been rejected everywhere else in the world. I just came this week from Jamaica and was talking about the British Commonwealth nations. I mean, Britain, Australia, Canada have all rejected pleas by press lawyers to say adopt the American Sullivan rule, and they all have rejected it as too press-friendly and as too antithetical to the reputational interest of celebrities, public leaders, and so on. So it's really, I mean, that's the reason everyone's talking about it, is that it totally changed the landscape and made us unique in our country as opposed to any other country, including our brethren in English-speaking countries and the rest of the world. So I think you're absolutely right that it really touches this case very deeply and all cases like it. Let me ask Steve, though, a question that troubles me a little bit in this discussion on satire, because you got to assume, right, that the reader, and whether it be a cartoon or whether it be written parody, gets it, that they realize this is kind of not true. And in the Hustler ad, it says this isn't to be believed out at the bottom. This is a parody. Mm-hmm. But I got an email not too long ago of something that purported to be an interview with an NFL player that was, quasi-illiterate. And it turned out it was kind of making fun of those who said that football players were kind of illiterate. But when I read it for the first time, I couldn't really tell. I wasn't really sure. Is that ever a problem? Because if people take it for the truth, then it seems to me we have a major kind of problem of whether or not it's harmful and hurtful and there should be liability. How do you deal with that?
Well, I'm trying to think of examples, and I can't off the top of my head, but there have been times where people have that a reaction very similar to that, and you chalk it up to maybe stupidity in a lot of cases.
Yeah, well, in my case, that's easy, but they're...
or just the fact that maybe that's maybe too harsh. Like some people just aren't really that sophisticated about satire and humor, and then there's the issue of we live in such a polarized time that people, their emotions kind of overtake their intellect, and they can't think it through. You know, they just get so heated. Oh, you're talking about topic X, or I love Donald Trump so much. How dare you? You know, and you don't have a normal discussion about something that other people might.
Okay. What about, Erica, you're a specialist in student speech. I mean, students could be part of the class that Steve just talked about, of people who are not that sophisticated or maybe not that knowledgeable. So two questions. Number one, does that paradigm that we just discussed kind of come into play in satire that's aimed at students, in student newspapers or what have you? And secondly, I would just ask, does Hustler apply in student speech, or are there other cases like the Tinker case which kind of override or have to work with it to kind of say, well, but even so, if there's disruption in the classroom, then it shouldn't be allowed?
Sure. So one interesting thing that several of the student speech satire cases bring up is, will that student audience understand it? And how important it is to create the opportunities for students to be able to engage with satire, to start develop the skills, so that as adults and as citizens and as voters, they can engage with the speech and understand it better. One key phrase from Tinker v. Des Moines, which is the 1969 case that sort of conveyed a broader First Amendment right to free speech.
This is where a student had an anti-war T-shirt, right?
Absolutely. Is this
Armband.
hazardous freedom, right? Life is this is an experiment, as all life is an experiment. When we talk about free speech, we talk about risk. And so we even see that in the public school speech cases and in the discussion of satire. It is a risk, but it's an important one. It's one worth taking, so that young people can not only learn how to create satire that is meaningful and purposeful and good, but also to engage with it, to be able to identify it. And so we do look at what is the likelihood, the plausibility of young people to see satire that is created for them by their peers, to understand it that way, but that the protection of it is important so that they can start to develop those skills. Now, we do look at student speech in public schools a little bit differently. The Tinker decision, which does convey First Amendment rights to student speech absent evidence of a material or substantial disruption to the academic environment, or a collision with the rights of others, has come in some of these cases. But courts have been cautious, and they've reminded schools that you cannot restrict speech simply because of undifferentiated fear, right? It can't be, I just don't like what they're saying, or I think there's a possibility that maybe we're going to see some kind of disruption. There has to be solid evidence. We have to see that outcome. Now, the collision with rights with others, that's come in when satire, parody, or that kind of humor is targeted at people, often because of physical characteristics, things like race, ethnicity, or gender. In those situations, we have seen some student speech regulation of satire be upheld because it ostensibly undermines the ability of some students then to engage fully in their education.
But can I ask you, because I got that in your paper, but it seemed to me that comes out of whole cloth and out of political correctness and not out of any law. I mean, the phrase, I guess, of the Supreme Court is that what obstructs others or interferes with the rights of others. But my sense was that meant a particular person, not 50% of the universe, like all females or all, racial, person of certain racial, and that's the way it's been used. And it strikes me that's just total political correctness, and there's no legal basis for that whatsoever. Am I being too extreme?
It's a unique application of the Tinker decision.
I think that means I'm right.
And it's one that's really being looked at very closely because there is that question of, are we trying to kind of skirt the law and the intent by identifying, well, here's one person who's been hurt and therefore that speech can be regulated, and what does hurt mean?
I mean, we talked a little about that last night in terms of the Charlie Hebdo ad, which really, cartoon, which really is about not an individual, it's about a huge religion that, you know, hundreds of millions of people are in. So it's hard to see that you know, harms the interests of others, unless we're talking about others in some sort of global sense.
Yeah, George, you know, so I really sense a unifying theme here, and it reminds me of something I say to my First Amendment students. I say, I'm going to give you a basic law of the First Amendment. It goes like, it's like quasi-Newtonian. It goes like this. For every action, there is an unequal and opposite overreaction. I mean, we definitely see it. We definitely see it in the school speech cases. You know, the case that John is talking about, where you have a coal magnate suing over an interview with Mr. Nutterbutter, right? It's just, and this one, the case we're celebrating today, for Pete's sake, there are two disclaimers that explicitly say, you know, what kind of humorless moron do you have to be to conclude that this is a good lawsuit to bring? But I really think that one of the unifying themes you can often find here is there's an impulse, people are offended, or there's a reaction, and sometimes they're even good impulses to try and, you know, make students' lives better, safer, so forth and so on. But they fall into this category of an overreaction, and that's why a lot of these laws get struck down once they're, you know, scrutinized carefully.
Just going back to the case we're celebrating here, and I just wonder if there's unanimity or everyone has their own answer. What was the point of this ad? What was the point of the satire? Who was it aimed at? Was it aimed at advertising? Was it aimed at Falwell or Falwell's mother? Was it aimed at just trying to be as outrageous as possible for the sake of outrageousness? Steve, do you have anyone have any thoughts on that?
Well, I mean, I don't know enough about the background, but I mean, was Falwell a big critic of Hustler? Presumably he was, right? Yeah. Because, you know, of the nature of what, so what they did. So he was just, I think, trying to stick it to him.
Just stick it to him.
As we say.
And to stick it to him, I mean, that makes it even worse from a legal point of view, because then the aim was to inflict emotional distress, which is the name of the tort. So that makes it kind of even better that the right side won, so to speak. Mm-hmm. But anyone have any other thoughts what the purpose of the ad was?
Well, if you take, you know, Larry Flint at his word in the deposition, that, you know, the idea was to cause harm to Jerry Falwell. The idea was to knock him off of a pedestal, and he's asked all these questions in the deposition directly, and I think that's, you know, the reason that Lynn mentioned that this is probably the worst deposition in the history of American law, because you can line up the elements of, you know, the tort, and, you know, he is ticking them off himself one by one in the depo. And so I think if you take Falwell, or Flint rather, at his word, you know, the idea was to, you know, to take a self-righteous, you know, leader of the moral majority, knock him down a peg, and in doing so, cause him some emotional distress.
Yeah, and self-righteousness is one of the most delicious targets for a satirist, you know?
That's a good point.
Yeah.
Len?
Well, George, I think this is a really important question, because this is part of this sort of texture that is present in a lot of satire, where you look at it and you think, boy, this could be saying a lot of different things. This could be making fun specifically of Falwell. This could be making fun of just, you know, self-righteous people generally. This could be making fun of the way in which self-righteous people become celebrities who get ads, you know, ad contracts with companies like Campari. There are, you know, there's some satire is sort of instantaneous in the way it works. This, I think it's ironic that Justice Rehnquist says this is like a distant relative of the satire we honor. I think this is like the relative that sits at the head of the table. This is way outrageous. This is really pushing the boundaries, and it's complex, I think, in terms of what it might be saying.
Let's go to the legacy, or at least where we are today in terms of this case. But let me start that by asking you, if the Supreme Court got this case today, but the Hustler case never existed, how would it come out? Would it come out the same way? I think with the precedent, it would come out the same way, because the court would, I think, follow their opinion of 30 years ago. But if there was no Hustler case back in our universe, what would today's Supreme Court, which is, actually pretty good on First Amendment, but not all that good in lots of other ways. How would they come out?
I suspect it would come out in much the same way for the reasons that you just mentioned. This has been, for the last 30 to 40 years, a highly speech-protective court across a variety of First Amendment questions. And I think that the precedent that Hustler relied on has been unchanged since the time of Hustler, and if we pretend that Hustler never happened. So if we say the 1990 Milkovich case, I think takes that ball farther down the field. Milkovich was a case in which the U.S. Supreme Court said that rhetorical hyperbole and in flourishes, using imaginative language and hyperbolic language, that gets First Amendment protection. And so I think that, even if, in that case did rely on Hustler, but it also, I think, relied even more heavily on New York Times Sullivan, the case that we keep discussing along with Hustler. So I don't know that you would see good reason here to say that the current Supreme Court would change, would have had a different reasoning than did the Hustler court.
I would say it would be longer. There would probably be more concurrences, and it would be a lot of that sort of, we don't like having to make this decision, but we're going to make this decision. I think the tone of it would have been different.
Yeah, and it's possible you get a dissent from Alito, because the Supreme Court has been really reluctant to identify new categories of unprotected speech. The animal torture case, the animal torture video case in Stevens, the violent video game case. The Supreme Court's not had any interest in creating new categories, except for Justice Alito, who seems to think that some new unprotected categories might be okay. So maybe you get a dissent from him, but I think generally it comes out the same way.
I just have this bad feeling that if we didn't have Hustler, the case, that most of us in this room would probably be in Leavenworth right now with our thin-skinned leader.
What I was really struck last night, George, your question to Ann about I think it was to Ann about whether the lawyers were involved, and the response was, I think, or I can't remember who the question was to, but the response was, we just work with our editors. And as much as I'm invested personally in the well-being of lawyers and their participation in this process, I think that's great that you arrive at a point where the answer is so clear that this largely becomes a conversation between journalists and cartoonists and their editors, and not where the lawyers are shaping what you're doing. So it's not only that you're out of Leavenworth, it's that you have out of Leavenworth substantial opportunities to really do what you want to do.
Do you ever talk to lawyers, Steve? I mean, I know that your former lawyer was a dear friend of mine, Hal Fuson.
Yeah.
Who was really a fun guy to work with, so I don't think you shied away from him because he was a terrible suit lawyer. But do you ever think about legal stuff? Do you ever talk to lawyers, or as Len has just suggested, is it even not even in the landscape, which was, I guess, a good thing?
It's really not even in the landscape. And what this has done is it's kind of freed you from having to worry about that legal stuff. And now we just have discussions with our editors, at least I do, about what's fair, what's the best way to make this commentary, or what's the fairest way, as opposed to are we going to get in trouble,
And is offending an entire religion something that would be okay under that criteria?
For me personally?
Yeah, sure. Or your editor, if it's different.
It would depend on the cartoon.
Okay.
Depend on the religion.
That too, probably, right?
Yeah.
So what is Len, what is the legacy of this case? How important is it today? Why are we here, kind of?
Yeah, so I think it's, go back to something I think John was hinting at. One of the things that comes out of the case is that you can't do an end run around the New York Times Sullivan standard. You can't just call it something else and get away with it, and I think that's terribly important. Hustler sets the stage for Snyder versus Phelps, which is an opinion where the Supreme Court goes, I think, even further in being skeptical about IED cases. This, I think, becomes more editorial judgment than a legal judgment, which I think is tremendously helpful. So I think it has a great legacy, not a completely untroubled one, sometimes when you try to apply it, the fact that there were so many disclaimers, the fact that the speech was so outrageous, the fact that you would have to have like an Olympian level of gullibility to think this was a true statement about Jerry Falwell. I mean, those things to some degree sort of limit the application of the case, but it still, I think, has a very strong influence.
In the Westboro Baptist Church case, which Len mentioned, which is the second intentional infliction of emotional distress case that the Supreme Court has decided in the last 30 years, was also a case with terrible facts. And we, at the Times, had the same dilemma of, are we going to join these people we hate in the interest of the First Amendment? And the answer, again, was grudgingly yes. And to do so, I had to point to all the places in the amicus brief where it was written that the defendant was heinous. So we don't like these people, we have nothing to do with them. This was the Westboro Baptist Church who basically protested outside of military funerals. So when a serviceman came back in a body bag and they had a funeral for him in a church, like what happened in the actual case, they protested, albeit with police authorization, like 1,000 feet or 1,000 yards away from, I think it was 1,000 feet away from the church, and they would protest and say the death was deserved because the U.S. believes in homosexuality, and this is kind of punishment in exchange for that belief is why this guy died. And so the father of the dead serviceman finds out about this protest going on at his son's funeral and sues for intentional infliction of emotional distress. So terrible facts, but again, the media, more or less, some of the media signed on amicus briefs in favor of the Westboro Baptist Church, and I think 8-1 with Alito dissenting, the church won. So for the free speech value won, despite really pretty disgusting facts. But the weird thing is actually, and I'd like someone to take this on, so the U.S. Supreme Court in the last 30 years has decided 2 intentional infliction of emotional distress cases, which is a really, really narrow claim, almost never brought, almost never successful, because what you have to show is that the behavior was basically unaccepted to civilized society. I mean, that's a pretty difficult standard to meet. And in that same time period, only taken 3 libel cases, which is kind of a really weird balance between a claim that's brought all the time and something that we don't really take all that serious in the first place. So I don't know, I went on for a while. Any comments to any of that? I left you dumbfounded.
I suppose maybe one comment I would make in general about, two reasons I like the Hustler decision, despite the analytic deficiencies that Lynn pointed out that exist on a couple of different levels there. One with the kind of odd importation of a libel fault standard and then elevating that standard. Another is, as Lynn puts it in his paper, it's taking the case one thought too far, in the sense that you could have resolved the case most likely on the issue of outrageousness, where the state claim and issue was, can you use, raise the question of, can you use outrageousness as a standard to judge an intentional infliction of emotional distress claim? And the court flatly said no, because that would empower a jury to use its own beliefs and biases to decide a case, and that would, of course, be too highly subjective.
And has our current president changed the definition of what's outrageous, since it seems he indulges in that every day? I mean, is that a problem, that outrageousness is kind of a moving target?
I would argue that, as I once said, this has been maybe a year and a half ago or so, that to quote Lord Varys from Game of Thrones, I think that Donald Trump would be content to see the world burn if he could be king of the ashes, and so where better to start the fire than the First Amendment, so to speak, and so I guess I don't have a sense of whether for IIED purposes our conception of outrageousness would change, simply because if we look at the Hustler decision itself, it takes a long view of what outrageousness is in the context of satire, and of course brings up Nast and Tweed and others going back many, many years. So I don't know if in the short course of a few years of first candidate Trump, then President Trump's commentary if we would have changed yet what it means to be outrageous.
Let me ask you a follow-up question on that, John, to something you said earlier, which is you were talking about the Murray case. And Murray is a billionaire, industrialist, whatever. Falwell was a major celebrity. Trump has sued all sorts of people for libel unsuccessfully, but had a lot of resources. And there's this sense, whether it be in these emotional distress cases or even in just plain libel cases, that people with lots of money are using that money essentially to force settlements out of the media, get the media to cower, to chill their speech, using litigation and their own resources as a tool. Right. And I think you allude to that in your paper. The question I would ask, though, is what's wrong with that? Especially since when I started the practice and the media then had lots of money, we basically used our resources to stall and to beat up on plaintiffs and eventually get them to drop cases because they were too expensive. So using money in litigation is not exactly a novel idea.
Sure. Yeah, I think speaking to that, number one would be my fear of the effect of that on the marketplace of ideas, so to speak, on whether it would create a chilling effect on speech. The other phenomenon that we have seen recently, and then again, this is not a new problem at all, but it has been the meritless nature of many of the threats that have been made against journalists and news organizations, by an individual or an organization with superior resources. If you consider about 2 years ago, a survey was done by the American Society of News Editors in which newspaper editors were asked the question, do you feel that your news organization is prepared to go to court to fight for the First Amendment? 53% of the editors said no. 27% of the editors said that they themselves had to pull a punch in a case that they normally would have brought or defended against in litigation rather than settling. And then if you move that into the context of freedom of information, a cousin, of course, to the freedom of expression, because we can't communicate what we can't gather, a recent Knight survey of FOIA experts found that it was something like 50% of FOIA experts believed that freedom of information had gotten worse in the last 4 years, and 90% of them believed, this was taken about a year ago, this survey, 90% of them believed that it would get worse under President Trump. So I worry in the abstract about the effect of meritless threats on on chilling the public discourse, and I worry about it especially in that kind of environment in which already editors feel and freedom of information experts feel that this is not the most liberal environment, liberal with a lowercase l.
It's funny because when Trump was campaigning and became president, he said he wanted to open up the libel laws. And putting aside the fact that A, he doesn't have the power to do that, it's up to the courts and the Constitution. B, what he wanted out of the law is essentially what the law is. He just didn't realize that. And C, what I wrote at the time was he ought to be careful because given his mouth, he's more likely to be a libel defendant than a libel plaintiff, and that actually has come about. He now is the libel defendant in a lot of cases and is using the very defenses that he was criticizing the media as having. So he ought to be careful as to what he wants. Do we have time for a couple of questions from the audience who I can't see? Yes, sir.
Quick question, which is in light of the meritless threats of litigation, and your response to these polls were journalistic organizations that actually have money and staff and attorneys or whatever to potentially defend them, and we're increasingly in a world where blogs and bloggers and people who it seems like the courts have construed aren't even necessarily journalists when it comes to revealing sources. Or other stuff, like I had a friend who was slap sued by Larry Klayman, attorney from Florida, and it was thrown out. It was totally meritless, but went on for a year and a half, and he stopped doing satire.
Right. Yeah, and they're in about I think it's 28 or 30 states. I can't remember off the top of my head. there are anti-SLAPP measures in place that are designed to allow a defendant who is, on the receiving end of one of those suits to get the SLAPP dismissed from court, and in the majority of those states to have fees shifted, so then the plaintiff who brought it against you would have to pay your fees for having inconvenienced you for bringing the meritless suit. But think of that, that's 28 to 30 states. The rest of them don't have that kind of protection, and you are left to try to defend against it with the usual tools of litigation, asking for, say, a motion to dismiss, or asking for, a summary judgment to be awarded. All of that costs a large amount of money. And so I think you're right. The people most at risk in this environment, it's not the New York Times, it's not CBS, it's independent journalists, it's the blogger who has taken it upon him or herself to create police accountability videos. That is the person I think most at risk.
Any other questions? Yeah, Ann? Yeah, Ann, go ahead.
I just wanted to go back to what you guys were discussing about, what was the purpose of the ad, why do such an awful ad. One thing that you're missing is the fact that the moral majority was a political organization. It's not about religion. You bring up the point about, can you attack a religion? When they insert themselves in politics, yes, you can. And the thing is, after the arguments of Larry Flint's lawyer went out, or actually Larry Flint went out, and he talked to the press and he said, it's not the extreme, it's not the milquetoast speech that needs protection. It's the extreme stuff that needs protection. So that's where that ad falls in, as well as cartoons that are so extreme that they offend people. So that was the purpose of that ad, to show that. It wasn't just to be disgusting, there was a purpose to it.
Okay. No, thanks. Yeah.
Good point.
As far as the students, do you think that some of the new criticisms of this kind of speech are coming from the left, that we want to protect people's feelings?
Oh, absolutely. This has definitely become a pressure from both sides, as both sides sort of redefine what it means to be sensitive in the academic environment and what students need in order to flourish within that. We see that both in K-12 as well as college and university level. I don't think anybody has complete ownership of the attempts to kind of censor on that collision with the rights of others.
When you're updating it and looking at our current Supreme Court, would you think that maybe the liberal justices would have more problems with defending critical speech?
I honestly don't know. I would like to believe that they would still see there was sort of fundamental value in allowing the speech, more speech rather than less. Let's get more ideas out there, and let's get government out of the way so that they can be discussed. I'm going to go with that's what I want to believe.
Yeah, I think it's actually very hard to imagine the liberal justices endorsing a principle of hate speech along the lines that is very often advocated for in the student speech. It's very easy to say we should be opposed to hate speech. Sometimes what I do with my students is I hand them a piece of paper and a pen and say, so define it for me, write down, explain, and the minute you get into that project, the vagueness problems, the overbreath problems, the definitional problems become sort of pregnantly visible. And so I don't see the liberal justices as parting company. I continue to believe that Alito is the lone dissenting voice on these fronts.
Not
sure.
The relationship between the value of satire and the Sullivan case all the way back to its original theory. Satire uses deliberate falsity of the tale to get at the truth. And in Sullivan, the reason for the actual malice test and the knowing falsehood was more about Nazi Germany and the use of repeated big lie to come across as something that was false but was intended to be interpreted as truth, which is part of what we're seeing with all the fake news attacks. But I think if you go back to the underlying rationale of Sullivan and the way in which falsity was perceived as a perversion of free speech, that satire's use of falsity really would be protected under Sullivan. Comments?
Yeah, so I mean, John, it's a great point. I think that and just slightly reframe it. Sullivan and Hustler are thinking about falsity both in different ways and in complementary ways. They're thinking about it both in the sense that literal falsity compared to, for example, metaphoric falsity. When we say the joint is jumping, we don't mean the room is literally going up and down, but we're getting at some sort of greater truth. Both opinions, I think, are sort of united in that, in the effort that there are different ways to get at the truth. When Justice Holmes says it's an experiment as all life is an experiment, what he's getting at is the idea that trying to figure out how we define the truth is just this almost impossibly complicated project, but I think you're right, they're complementary. All right, one last question.
I'm not sure how much of a question versus a comment, but I haven't seen any analyses yet. And that is that if Hustler had just written an article alleging these things to have happened, and as opposed, because the parody was Campari, and I've never heard whether Campari weighed in on this or not.
By the way, I wonder why we didn't have Campari last night at the reception. I think that would have been appropriate.
So I guess the question is, was it so the parody was of a Campari ad campaign, and if you pulled the whole Falwell element outside of that parody, the results might have been different. And so I'm curious to know, I maybe just open that up a comment, to what extent the context of parody allows you to get to something that would otherwise be outrageous and actionable.
Oh, sure, the context makes all the difference. I think we would agree. You could write an article that's actionable where it's presented as a news piece. It says, we just learned from independent sources that we verified that he had sex with a goat and then with his mother, so forth and so on. And one of the funny things about his deposition is that in his deposition, Larry Flint essentially said, well, that's really what I wanted to do. And I, in fact, had affidavits that I still have somewhere that confirmed that this stuff is all factual, but they kept wanting to call it a parody. Again, the worst deposition in the history of America.
It's a miracle that this case was won. Thank you, panel. Thank you very much.
Thank you, panel, and George Freeman. And I'm just going to make one quick observation as people were walking down memory lane. I recall that during the oral argument, Alan Isaacman, who was arguing in support of Hustler magazine, said that the way that Hustler magazine conducts political speech is not the way the New York Times does, and that the very outrageousness of the speech was the way that the readers of Hustler would communicate these ideas. And I think that's a critical point to keep in mind. Okay, it's just after 11. We will be back at 11:15 to hear from Professor Sophia McLennan. So please take your break, but please be back at 11:15. Thank you.